Hey guys, Ray from bailbondbidsnow.com, the marketplace for competitive bids. But anyways, today I'm here to talk about what, in my opinion, from my practicing days as a defense attorney, a seriously underutilized tool to try to help individuals that are charged with crimes. And so today we're talking about the Texas examining trial. Remember, an examining trial is not like a regular jury trial or anything like that. It is basically a tool that has to be done very, very early, almost right after somebody's arrested. An examining trial, as shown here, is basically to show a judge that probable cause did exist for this arrest. And you also have to remember, if a formal charge is filed called an indictment, then that negates the right or stops the right to an examining trial. An examining trial is just done before the judge, and it's done by an attorney filing a motion before a formal indictment is made. And then the officers will have to come in, or the investigator, in order to establish probable cause. Now, once again, a defendant does not have to testify out there, but he can if he wants to, he or she wants to. The good things about an examining trial is you have to push the court to try to get it, because within a short duration of time, an indictment will usually come. And so if you have that examining trial, if you're successful, you can actually have an occasional dismissal. A lot of times you get early evidence instead of waiting for the formal process to get there. And then that kind of gives you a heads up on who you need to talk to, how to investigate before you're able to review the prosecutor's file. And remember, it's important because prosecutors and their investigators don't have to show that you're innocent. They only have to show that what they believe shows that somebody's guilty of a crime. Now, remember, a lot of times attorneys will file a motion for this and they'll push the court to get it on their docket so they can have a hearing date. But prosecutors will usually go to the grand jury, not a regular trial jury, a grand jury. It's a group of individuals that sit and they basically stamp whatever the prosecutors bring to them for approval as a formal charge. They will take it to that grand jury in order to hurry up and get it formally filed so they can do away with an examining trial. My father and I practiced together, and probably over 20 years, we probably had about 5 to 7 that were dismissed and over time, and a couple that were actually dismissed by the judge. The last thing is, on an examining trial, this is one of the reasons you should try to make bond, because you make bond, you're able to go out and hire an attorney, and you could do it quickly. They can act on this and they can file for that to try to get that examining trial. If the court appoints you an attorney, it's usually too slow. And by that time, an indictment is just around the corner, or it's already been formally filed. And a lot of times, most court appointed attorneys are not going to try this. So in our humble opinion, it is a very, very much underutilized tool. It's a lot of work for attorneys, and a lot of them just don't do it. But if you're charged and you make bond, go out and interview attorneys and ask, do you think this is something we should do an examining trial on? But it's got to be done quickly. All right. Hope this helps, guys. Bye-bye.